Greetings, friends. Keith Costello here. So, fighting the American Revolution was expensive. And when we had won independence from England and were going about the business of governing ourselves, we ran into a number of major issues that were leading toward economic collapse. The states had taken a lot of debt in order to fight the war, and they had mechanisms for taxation and funding so that they could pay on their debts, but the federal government did not. And in fact, because the federal government had to rely on approval from the states for any revenue creation they wanted to take up, they had soldiers that had faithfully fought in the Revolutionary War who had not been compensated appropriately, hadn't been given what they had been promised. And the ripple effect of that was affecting sort of every corner of the economy. You had national debtors, that countries that we had borrowed from, that had given assistance, that we owed debts to. And so all those things were mounting, and the federal government was very weak. Under the Articles of Confederation, the first governance system, the federal government had very little authority. And it was in that context that our Constitution was written. The Constitutional Convention was convened. It wasn't actually known to be a Constitutional Convention when it was convened, but that's what it became. And ultimately, they wrote the document that is our Constitution, and we were able to navigate through the ratification process to put the Constitution in place. It required the first 10 amendments, the Bill of Rights, before the full completion and promise, the guarantees that had been made by people in the ratification process before all of that had come to fruition. So the Constitution with the first 10 amendments were ratified and became our rule of law. And one of the major controversies that's come out of that has to do with states' rights. The Civil War itself had a lot to do with states' rights. The southern states believed they had the right to secede from the U.S., and obviously the northern states and the federal government did not agree with that. It was one of the major factors in the Civil War. By the way, as an aside, I do believe that slavery was the predominant issue of the Civil War, and the scars of just an unholy compromise that was made in the forming of the Constitution that needed to be amended and was amended by the 13th Amendment was the great scar in the American founding that had to be addressed. But states' rights were a point of very significant confusion of who had authority. And so the Civil War also had a lot to say about the way that states' rights were taken. The reason for that is the 10th Amendment of the Constitution guarantees to the states rights that are not expressly, or powers that are not expressly given to the federal government. And so states have considerable authority. We have a federal system of government, which means there are local governments, then there are state governments, and then the federal government. And the new Constitution, as opposed to the Articles of Confederation, gave much more power and authority to the federal government. And that was ultimately tested during the Civil War when those things were recalibrated. So the 10th Amendment reserves powers for the states that are not expressly given to the federal government. But when that happens, it can be used to test whether or not federal statutory law applies and violates states' reserved powers. But what it cannot be used to do is to give states authority that contradicts the U.S. Constitution. So the level of authority needs to be really clear. When the Constitution was ratified by all of the different states and the United States was formed, the constitutional law, the Constitution, is the umbrella law over all other laws. So what is not expressly given to the federal government in the Constitution is reserved for the states, according to the 10th Amendment. That does not mean that the states can undermine authority that is expressly given to the federal government in the Constitution. So, for instance, the provisions of the Constitution itself, including the Bill of Rights and including the first part of the First Amendment, which is on religious liberty, are guaranteed nationally. They cannot be undermined by states' rights. States do not have reserved powers to establish a church or to undermine individual religious liberty, because those are protected by the Constitution, which is above state constitutions and state laws and all other federal laws, right? It's the highest law of the land, the Constitution. So none of those things are allowed to violate the Constitution. But what we have seen is states at different episodes, of course, Civil War was a big example of that, where they're claiming the states' rights can supersede even what's in the Constitution. And the war itself gives evidence to the contrary. And just the function, the very fact that the Constitution reserves powers for the states in the 10th Amendment is a verification of the Constitution's authority over states' authority, right? So that cannot be violated. And yet, we have education. Education has been one of these areas that, because it was not expressly mentioned in the Constitution, it was considered part of, and rightly so, part of the reserved powers of the states. The states had the right to organize their education systems in their states, with one really important frame. They cannot, no state has the authority to violate constitutional rights with the way that they structure education. They have the right to govern education, but they cannot do that in a manner that violates constitutional rights. And that's exactly what has happened for decades and decades in the United States of America. So you have the 11th Amendment, which, again, these are the 10th, 11th, and 14th are your amendments that really talk about states' power versus federal power in one way or another. And so the 11th Amendment, of course, suits against a state. So typically you need a permission of a state to sue that state, or you have to be a citizen of that state. You can't be a citizen of a different state and sue a different state. And that gets into details which are not applicable for our point of discussion here. And then the 14th Amendment is really covers the protection of rights against state infringements, right? So in some ways that's going the other direction, that states don't have the authority to undermine individual rights. And so the Constitution is not long. I recommend everybody read it, right? Read it from cover to cover. You can do it in one sitting. It doesn't take that long. And read these amendments and understand what they say. In some cases, the language feels a little old, but it is not difficult to understand what was intended by our framers when they wrote the Constitution. So here's what happens with public education funding. So from a constitutional federal level, funding education is not required. The Constitution does not say that the United States Constitution does not say that we have to fund education. Many of the states' constitutions have provisions that require the state to fund education. That's important to remember. And that, I believe, is part of their reserve powers. They have the right to ensconce in their constitution that we're going to pay for public education. They have that right. And a majority of the states have those provisions in their state constitutions and other state law. And so that's part of their reserve powers. The states, however, cannot violate the Constitution with how they fund. Just because education and education funding would be part of reserve powers, it doesn't mean that those structures that they put within it can violate the overall Constitution. So, if a state has a school funding paradigm that violates the U.S. Constitution, it is unconstitutional and it's illegal. And I believe all 50 states are in that category. All 50 states violate the Establishment Clause and the Free Exercise of Religion Clause. And I think there are equity ramifications of the Constitution that all 50 states are also violating. So the government cannot establish a state religion. So any state that has said that any content can't be taught in a school at any point, they have violated that standard of the Constitution. The problem is they saw themselves in a no-win situation. If you have a teacher and a student who are of different worldviews, different religious foundings, and the teacher teaches from his or her worldview, religious perspective, and it's against the students, then there's a real legitimate argument that both the teacher and the student's rights for freedom of conscience, freedom of religion are being violated in that situation. That public money is being taken and is paying that teacher to teach, and you've got contradictions in religious systems that are on full display right there in a publicly funded institution. So in order to try to address that more and more, we tried to push religion out of education. The difficulty in that is that it is not possible. That is an impossible task. All knowledge, all education systems, all curriculum are based on presuppositional beliefs. They are based on faith positions. There is, and never has been, the occurrence of an irreligious education system, curriculum, content, none of it. All of it is based on presuppositional faith ideas. It is not possible to have an education that does not have a religious founding. A part of what has confused that is people have contrasted religion with science, particularly here in the U.S. In the 20th century and onward, have contrasted a scientific point of view, a materialistic point of view, with a religious point of view. But in that case, a materialistic point of view is the religion of those proponents. If you go back to the original Humanist Manifesto that was signed by a number of 20th century luminaries like John Dewey, for instance, and a number of major educators were part of that group. This is a group that believed the only thing that existed is the material world. And so anything supernatural is false. It's imagination, superstition, it's, this or that. All that exists is the material world. There is no God. They were not agnostic, they were atheistic. There is no God. There is nothing outside of the realm of just physical reality. Well, that is their belief system. And when they first signed the Humanist Manifesto, the first edition of that actually talks about that worldview as their religion. It was their religion. It is their religion. But over time, there was a recognition that if they downplayed the sense of this is our religion, this is just a scientific viewpoint, then what we can do is get all the other religions pushed out of public education where we're the ones in charge. And there was a systematic, you can track this in letters that were correspondence that happened between members of the humanist societies and so on and so forth. But regardless of whether you see that written or not, it is clearly logically evident that all knowledge and instructional techniques are based on belief systems. So this idea that we can benefit one without harming the others it's ludicrous. And our entire public school funding paradigm is built upon this ludicrous notion that you can have education that's devoid of any religious sentiment. And so we can not fund anything connected to any religion and we'll fund secular humanism. And somehow we're not violating the Establishment Clause. in the effort to avoid violating the Establishment Clause, we have utterly adopted a system that has basically enacted total war on that principle within the Constitution. We have only one worldview that is allowed within the public education system. We're taxing everybody, and then we are giving them a materialistic, secular humanist education, whether parents and students want it or not. That has to come to an end. So states' rights exist, and most states' constitutions require the funding of education. If that weren't the case from a federal level, you could say, well, you have a couple of choices. You can either fund education pluralistically and equitably. That would meet all the standards for constitutional requirements. Or you could not fund education at all. You just say, we're not going to be in that at all. That's not what we've done. And then at the states level, because of states' reserved rights, because so many of the state constitutions require that the state funds education in that state, they are going to have to fund education, but they cannot do it biased to one religion over another, which means if states are going to fund education, and if the federal system is going to fund education, which right now it does, all of that funding must be pluralistic, where it honors religious liberty of all U.S. citizens, and I believe it also must be equitable. Now, defining that is difficult, and you're going to run into more nuances on states' rights. I personally believe that the funding paradigms have to be established at the state level because of the reserved powers, but I believe that the constitutional arguments definitively require pluralism in the religious aspects of education at the state level and the local level beyond that. And that I also believe that the Constitution has something to say about equitable funding within the states, not across states, but within each of the states, which I'll cover more of that in later episodes. But the point for this episode is that states have reserved powers. They do not have undermining powers. They cannot set aside the Constitution by what they set aside, what they put in place using their reserved powers. The reserved powers still must be utilized in a manner that is submissive to the highest law of the land, the Constitution of the United States, which requires any school funding must be religiously pluralistic. Now, a lot of people believe that that makes for a non-workable contradiction. I disagree entirely with that perspective. The fact is there has to be transparency, and I believe that if we had true full school choice where parents were making the decision of where they want their kids to go to school, schools had to say what philosophical and religious perspective are we teaching from, so that employees have to agree with that and align with that with the school. So there's transparency for teachers and for administrators and for parents and for students. All those families are choosing schools that align with what they want for their child. So if you have a Christian family that wants a secular humanist education, they can choose that. If you have a secular humanist that of the options available to them wants the Christian school, they can choose that. If you have the Muslim who is willing to accept the Buddhist beliefs and put their kids in the Buddhist school, they're making that choice, but that those worldviews and the religious perspectives are clear and transparent, and the teachers know what you've signed a contract here. This is what's expected that you will teach here. But you are not, by the public funding paradigm, violating that teacher's constitutional rights to practice their religion, right? Because this is the only publicly funded school available, and they're requiring that I teach like a secular humanist. That violates the Constitution of the U.S. So what can you do? I would ask you to join our Be Wise campaign. WISE is an acronym. W stands for watch. You're watching the videos right now. Then I is for imparting what you have learned. I'd ask you to like the videos, subscribe to the channel, and most importantly, share this content with others that you know would be interested. S is sign the petition. We've got a very simple petition on our website that's listed down below this video. Go there, fill that out, sign the petition that you believe that religious liberty is ensconced in our Constitution, and it requires a pluralistic approach for education. It's clearly laid out there. I'd ask you to sign that petition. And then the E is empower. And as we continue this work, we need some monetary funding to continue the effort to push this into judicial review and ask the Supreme Court ultimately to rule on whether or not our education funding paradigms are constitutional. So you can look at a one-time donation, or you can become a sponsor and have recurring gifts that you provide to the organization so we can continue this important effort. Blessings to you.